exposition of the development of the law in this country. Today, she's going to talk about the Whiskey Rebellion of 1795. Now, let me digress for a moment on something personal about the Whiskey Rebellion. I, as some of you know, was a history major in college, and American history was top of the list. Every course I took mentioned the Whiskey Rebellion. I never understood why it was mentioned every time or why it was important. Now, maybe either it wasn't explained or my skull was too thick to absorb the explanation, and if you're betting folks, don't bet on the fact that it wasn't explained properly. But in any event, my theory was it was a bunch of lawless folks in western Pennsylvania that were distilling hooch, didn't want to pay tax, and the government said, you have to pay tax, and made them pay tax. I think Linda's going to explain that there's a bit more to it than that. And so, Linda, people want to hear you, not me. Take it away.
Thank you. Hi. Congratulations, you survived 4 and you're up for 5. There's only 3 more left. This is the 4th of 7, and the next one will be, it's called Sangrado v. the Cloven Hoof. I thought I'd get sexy. But that describes Dr. Benjamin Rush and William Cobbett. William Cobbett was the favorite journalist of Abigail Adams, in case if that makes a difference to somebody. Today I'm going to introduce in a kind of funny way. I'm going to talk about Manuel, I think his name is Lin-Manuel Miranda's Hamilton. Yeah. So in a earlier draft of the musical, which was opened in 2015 on Broadway and won 8 drama critics, 11 Tonys, a Pulitzer Prize, and a Grammy. Oh, wow. That's great. Yeah, just leave it up. That's good. Thanks. He had included a song in the Whiskey Rebellion, which was cut in the last version. And he got it pretty right. He got very close to where I'm going to land up on the rebellion. He's got Washington, much like the Roman general Cincinnatus, distracted by his desire to retire to his country estate and preoccupied with memorializing his run as president. He's got Hamilton egging him on and warning him history has its eyes on you. And he's got Washington purporting this leading of the troops against these rebels as his last ride against an outgunned, outmanned, outnumbered, outplanned bunch of tax dodgers shouting, "Pay your fucking taxes, taxes." Not a Washington you hear about very often. Today I'm not going to rag on Washington so much. He's going to get some things right, because as we said at the end of last time, he learned as he went along. And I'm going to take the position, which has not been taken by the scholars of the rebellion, about whom several books have been written, and I'm close to completing my contract with University of Georgia Press on a new book on this issue. A plethora of scholarly articles, but the historians have largely stopped cold on the issue of this being any more than a non-ideological, rabble-rousing bunch and a radical mob. I'm going to take the position that they haven't understood what the ideology of the Whiskey Rebels was all about, because they haven't studied the assemblies, and I will introduce some of these assemblies to you. There were 7 assemblies, 7 Whiskey Rebellion assemblies, and assemblies on self-governance in western Pennsylvania goes all the way back to the 1780s, a very famous one in 1787 where a lot of the rebels were represented. But they weren't sexy assemblies because they dealt largely with self-governance issues such as open access to the Mississippi River, which was controlled by the Spanish, getting rid of British forts in the area. According to the Treaty of Paris of 1783, the British didn't take the forts out. Debt crisis, lack of currency. There wasn't currency. That's a problem in paying your debts. The failure of the government to, as we discovered in the last case, to honor settlers' rights to land, as opposed to land titles by wealthy speculators. So there were a number of governance issues that occupied those assemblies, and my contention is going to be that those self-governance issues carry right through the Whiskey Rebellion, and if anybody would sit down and look at the list of grievances that they presented to the U.S. Peace Commission that Washington sent west before he invaded the West, and if anybody sat down and looked at the petitions and resolutions that came out of the assemblies and were sent to the state legislature and to Congress, they would discover that these are continuing issues, and a primary issue is the way settlers are treated with regard to land access in the West. So whiskey is now, in my view, going to be an issue, and it's going to be an inciting issue, but it is only a part of a complex of issues, and they largely circle around the issue of self-governance. By the time I finished the book, I was pretty much convinced that I had written a book that will explain the Trump mob, and in a lot of ways, not excuse it, but by explaining it, giving it some respect. And I'm kind of embarrassed at that. But I had written a book on abortion where I started out as a pro-choice and wound up having some respect for the people who were pro-life. So I think it's the question of following your sources and going where they go and trying to keep the conversation alive. So it's not an ideological set of discoveries that I've made, but it does give them a voice. And I think the voice is an important one, and we can learn something from it. Okay, so we are going to be taking away, I hope, from this, an understanding of the importance of participatory democracy and the role it plays in balancing centralized government power. The rebels' mantra was constitutional resistance. You couldn't hear it because the radicals kept going off the reservation. But to the extent that the moderates ultimately prevailed, that became their interpretation of the Constitution, which the George Washington's administration considered an oxymoron. You can't have a Constitution and resist the Constitution. So we will see how that affects their popular theory of popular sovereignty. But I do think that this balancing of government power is the contribution that the common people make to American democracy, and maybe that's where I will land up with this book. Okay, so where are we at? We ended in 1786 with the Washington land case, and the Revolutionary War had ended. Now that means that by the time we get to 1794, we are no longer under the Continental Congress, which was a unicameral legislature with one vote for each state, and that vote is appointed by the state legislature. There is no judiciary branch, no judicial branch. There's no executive branch under the Continental Congress. Any policies that they arrive at had to be approved by state legislatures. And in my view, even though they delivered the Articles of Confederation, which was regarded as the Constitution, and they were themselves referred to as the Congress, they were really neither. I think they were just a wartime government to a large extent. And I welcome being corrected on that, but that's kind of where I ended up. So before it leaves office, this Congress asks each state to write a state constitution. This is now during the war, now coming out of the war years. They're going to each have a state constitution by the early 1780s. And to draw up a treason statute for that state, under which they operated to try treason cases during the American Revolution. Pennsylvania's treason statute is going to pretty much end its effectiveness in 1787, which is when we will get the U.S. Constitution, but there will be overlays of it, and one of my readers has asked me to explain the role of the state statutes in the Whiskey Rebellion treason trials, and I don't find they have a role, so I don't know how I'll answer him on that, but it will be a struggle. So now we are operating under a U.S. Constitution now, in 1787, a representative democracy, and in 1791 we will get the Bill of Rights, the Whiskey Rebellion, which will rebel against the imposition of a federal tax. Remember that taxes and revolts against taxation were pretty much what did in the British Empire with regard to colonizing America. And so we are going to get a challenge here that will be an existential challenge to the actual union of states, with the idea that each individual state, now that it has its own state constitution, has the right, in effect, to trump what, in quotes and not a pun, the federal constitution on issues of importance. The problem here is that the treason statute that Pennsylvania arrived at and used during the war was very important because the major treason trials of 1777 and 1778 were conducted in Philadelphia under that statute. So there are residues of it. Now, these trials are going to be tried under the U.S. Federal Circuit Court, where will be sitting a Supreme Court justice and a district judge, both federal judges, in a federal court. But the district judge learns a lot about his district and brings local law, state courts, state law into the discussion. So we can't entirely discount that. But this is a constitutional case because Article 3 of the Constitution is the controlling law on the issue of treason after the establishment of the U.S. Constitution. And it basically says that you may only be tried for treason for levying war against the United States or in adhering to their enemies. They would refer to the United States as involved because they are states in the plural. And it requires the testimony of two witnesses to the same overt act. Doesn't sound like much in terms of language, but Benjamin Franklin was very insistent that it should say two witnesses for fear of perjury, which was the common complaint against the British when they made charges of treason. And remember that their charges of treason were against the person of the king. So judges were, in order to ingratiate themselves, tempted to construct treasons beyond what may or may not appear in the common law in order to please the king. But here we have the people themselves are sovereign under the U.S. Constitution. So the treason will be against the people, which should eliminate constructive treasons, where you expand the number of treasons. But the Constitution will also make clear that treason shall consist only in, and that's a super control over expanding the number of treasons. It can only be levying war or adhering to the enemy. And Benjamin Franklin makes sure that it must be two witnesses and not one to correct for perjury and for political collusion and for making treasonous charges against your political enemies. So there's a lot that goes into the article that isn't apparent on its face. And it says the same overt act. So that means not just a treasonous act, but all your evidence must be by two witnesses to that treasonous act. Now, that treasonous act as an overt single act and constructing treasons to expand them beyond levying war and adhering to the enemy are the protections that are going to play into these cases and how they are adjudicated, how they're litigated, and the end result of nobody being executed. It's kind of a weird thing. Okay, so I just want to call to your attention that in the American Revolution, the facts and figures with regard to who got convicted are very strange, and so are they in the Whiskey Rebellion. Because, well, we're not quite sure why. One of the reasons is because of the question of allegiance. You owe allegiance to, question mark, right? And therein lies the treason, because it is the levying of war against the party to whom you owe allegiance, but the implication is that that party owes you protection. So allegiance is the counterpart of the protection, right? The sovereign protects you, you owe allegiance. And to levy war against that sovereign is to destroy that the reciprocity of that relationship. So I have the figures here somewhere, number 4, and you will or will not be surprised to find that in the American Revolution, remember, Pennsylvania is the state that tries the most cases. So I'm using the figures for the American treason trials in 1777 to 1778, which were the most important ones. Only 87 people were charged with treason, 54 were indicted. There's a slippage, right, between the charge and the indictment. 45 were tried off of that indictment. There's some more slippage. 7 were convicted. We're sliding into oblivion here. 4 were pardoned and 3 executed. In the Whiskey Rebellion, we get these figures: 36 charged, 24 indicted, 10 tried, 2 convicted, 2 pardoned, 0 executed. This is peculiar. This is the highest charge you can make. You deprive somebody of their life for a treason which threatens the existence of the state. And yet you get these kind of figures for cases about which volumes have been written. So why does that happen? And I'm going to have several reasons of why. One is going to be because the evidence is not there. The evidence that's collected is corrupted. Then there are questions of vicinage. Where should you hold the trial? And if you hold it in the wrong place, the verdicts are going to change. There'll be procedural issues. This is like nothing. I mean, people think, okay, problems of process are of interest. They're on your way to the real trial. In fact, in the Whiskey Rebellion trials, they become the trial, the real trial. Questions of jury selection, and then questions of constitutional interpretation. So those are the issues that I think the rebels won on. They played the game around those, and they were very successful at it. And I'll, as we work our way through, I'll explain some of that. Okay. Just on the question of allegiance, I just want to make clear that it's an interesting, a very interesting issue. And we won't go into it too deeply, but consider this. Were the Indians traitors? They signed treaties with the U.S. government, and then they fought wars against them. There was never a single treason case against an Indian. Were Americans traitors to the British by revolting against the British Empire? There was not a single case of an American tried for treason on American soil by the British. Well, you know, in the Pennsylvania treason statute, as in other state treason statutes under the Continental Congress, it says treason against the state or the United States. It's interesting. So is treason against a state? Connecticut settlers seceded the county of Wyoming from the state of Pennsylvania under that Treason Act. And then again, they tried it again in 1787 under the U.S. Constitution. And in neither case were they tried for treason. It's interesting, because one of the charges against the Whiskey Rebels is going to be that they were being tried for secession. They wanted to create their own independent state because the reciprocity relationship had broken between them and the United States. So, you know, who owes allegiance to whom? What does that allegiance? What does it constitute? Those are interesting ideological issues that were not brought up in the trial, interestingly enough. But Hugh Henry Brackenridge, who we mentioned before, was a rebel who was asked by other rebels to represent them in the trial, and he decided not to do so because he wound up being a witness. He was a witness for the defense, and he was a witness for the prosecution in 3 different cases. This is a peculiar man. But after the trials, but during the trial he took notes and wrote this document, and after the trials, in the same year of the trials, he published his notes for a defense of the rebels, in which allegiance was the central issue. Did they or did they not owe allegiance to the Brits? And his claim was that allegiance of the type that was required by the British Empire was a feudal concept that required a master-slave relationship, and since that was absent, and that there was no legal justification for that in the colonies, that we owed no allegiance and therefore there was no treason. But that never came up in the trials themselves, although his dissertation on treason was in fact written as the defense he specifically says he would have offered on behalf of the rebels had he been able to represent them. Okay. I'm zipping through here, keeping time. There are 3 things I want you to be aware of, just as a general contextual note, behind the revolution, because we're in a very specific place in a very specific time. I had made a note to myself, and I forgot where I put it, about a piece I had read on Matisse, which some of you may have read in the New York Times, where he painted in such a way that he wanted to help you see the colors, the lines, the shapes, but not the scene, right? He wanted you to see what he thought were the real things, the important things, not the scene itself. And that's the approach that I've been using, more or less, to show you the lines and the colors, all that makes up the structure of this case, without giving you just the story of the case, the scene itself, which for me is not dispositive, because there's so much underneath it and behind it, and so much that it's made up of. So in the end, you're freer to draw your own conclusions. On the other hand, there may be, the picture may be a little frayed around the edges because you're not going to get it full face and frontal. Well, here are 3 things that are shooting up from behind the scene that I think are worth noticing, because this trial and this rebellion take place in a real time and real space. So what were the contextual features here? There were 3 as I see it. Legal primitivism, colonization in a post-colonial context, and the backcountry as a foil for the city. So let me explain them. In the West, in the frontier, there was nothing but primitive law. There were local traditions of self-help, cooperation, retribution, direct redress of grievances, and there was a thing called the posse comitatus, which means the community self-defense call-up, where everybody's duty is to defend the community. And that becomes the basis for legal primitivism, becomes the basis for militia. Now, we know about the Second Amendment militia right, which is a well-regulated militia, and to create, hold it. We need to have the right language. Amendment. To secure the state. Okay, I just remembered it. So a well-regulated militia to secure the state is not the kind of militia that was the arm of the rebel assembly, right? Because it would not create the conditions for democracy. All right. But that is what we have. And the militia had a traditional role of maintaining the order on the frontier because there was no presence of a police force. And so it had that traditional role. It was a right then to, and as well as a privilege, because it reads both ways in the law, to maintain an arm. It was a duty to respond when called up to use those arms. It was a property right in the ownership of those arms. And it was a responsibility in defense of the community. So the Second Amendment is going to come into play here because this is going to be something on which the government will hang its hat. It appreciates that there is this right on behalf of the militia to own, and it is a duty on behalf of the militia to respond, well-armed, in defense of the community. And that will go to the 1792 Militia Act, and that will go to the Second Amendment of the Constitution. It will also go to, I think it's Article 8 of the Constitution, where it gives the duty of defense to the militia. But they will be accused of treason for carrying arms in defense of their community in the treason trials. So that will be of some importance. Now, the second part is colonization in a post-colonial context. We are now post-colonial, right? Colonies have revolted. In what sense, then, are they colonized? Well, the West felt colonized by the East, because in the East were the forces of the founding elite, whose interpretation of the Constitution and of democracy described what was happening in the East, but was imposed on those in the West. And so what you need to know about that is that the West was not invited, Western delegates were not invited to the Constitutional Convention for the U.S. Constitution. So they had no role in forming it. They were invited to the ratification convention by the state of Pennsylvania. And 7-2, the Western representatives voted against the U.S. Constitution because they weren't invited to write it. And then they held their own constitution in Harrisburg, which failed, which had intended to amend the Constitution to represent their interests. So they are not happy campers. So in that sense, they feel colonized. The representatives, the Western representatives to the ratification conference were anti-federalists. The Constitution is a federalist constitution. They stood for states' rights. And 5 of the 7 that voted against ratification, unsurprisingly, became leaders of the Whiskey Rebellion and the architects of the ideology of popular sovereignty that was on which the rebellion was founded. So there's some long roots here that are of interest. And nobody really looked at this. I'm surprised. Thank God they didn't. Because it was good. I found my niche. Okay, now, so the settlers feel themselves colonized. Interestingly enough, they're after the land in the West, which means that they are not only the colonized, they are the colonizers, because they're stealing the land from the Indians, right? They are both, then, disparaged minorities. The one is, they are both made peripheral to the center being the East, right? And they have been marginalized. So there's that contradiction, there's that ambiguity. The third one is the backcountry is a foil for the city. We know about the North-South split, which was already inherent in what was going on politically in this country because of the concessions that were made to slavery in the Constitution. So that's pretty clear right there. But we don't really think about the East-West split as anywhere as consequential as the North-South, and certainly not something that would provoke a civil war or the disunion of the Union. That wasn't true in 1794, the year of the rebellion. There were 3 rebellions, one in each of the first 3 presidents' terms, that threatened the existence of the United States. The first was the Whiskey Rebellion under Washington. The second was the Fry's Rebellion in eastern Pennsylvania, right near here. Again, a tax rebellion in John Adams' administration. And the third was the Aaron Burr's revolt against the government of Thomas Jefferson. And all of them wound up being treason trials. The third one wound up being a treason trial in the U.S. Supreme Court, the other 2 in the U.S. Circuit Court of Pennsylvania, the same court. And the Burr trial under Jefferson will make the course correction that demonstrates that the defense had a better case than the prosecution in the Whiskey Rebellion trials. And I'll show you that language that Chief Justice John Marshall uses, which is very peculiar, to nail that issue. So the backcountry is a foil for the city. The frontier is distinctive. It has its own what's called, in quotes, vernacular sociology, meaning a kind of indigenous, almost vulgar, local, or common sociology that was totally distinct from what the founding elite represented in the cities in the East. The founding elite are, peculiarly enough, described as counter-revolutionaries the minute that the revolution is over. So Washington and, well, all the Federalists for sure, but even Madison and Jefferson were regarded as among those who wished to craft a kind of government that was really against what the revolution stood for, according to the Anti-Federalists. And that's an interesting sidelight to history, which we won't be able to go into, but it does represent this distinction between backcountry and city. So the people in the West were individuated, that is, they get their identity from frontier life of this kind of dispersed settlement in antagonism to coastal authority and the existing law that's represented by the founding elite in the city in the East. And that's the distinction between East and West, which sponsors this rebellion, and to some extent the Burr Rebellion, but not the Fry's Rebellion. Okay, so I think we can move on just to show you. I'm going to give you some visuals just to give you a sense of. We can do the first visual. A sense of the place, the time, and space. Just 4 images, and the first one will be anti-federalist clubs, to give you an idea of the anti-federalism that stood in the background to the rebellion. These clubs, there were 40 of them throughout the states, and you can pull the. So in the 1790s, these they were called Democratic Republican clubs. I know that sounds like an oxymoron, but we didn't have political parties in those days. So there was Federalists against Republicans, but they weren't really political parties until the 1800s. And these clubs grew up in opposition to the U.S. Constitution. They were pro-French or Jacobin. And they were largely bourgeois debating clubs, a little raucous, as you can see here. They were not like the proletariat frontier radical style of anti-federalism. But there were 3 of these kinds of clubs that existed in Western Pennsylvania. That's why they're worth mentioning, beyond the influence that anti-federalists had on the rebellion, as I outlined. the mouth of the Y-O-U-G-H River, and the Mingo Creek Democratic Republican clubs, there are two different clubs, and then the Washington County Democratic Republican Club, or Society, existed in the counties where the rebellion will occur. The first two were militia-based and shared members of their society with the armed force of the Whiskey Rebellion and attended their assemblies. So there's a connection there, but it is not sufficient, in my view, to justify Washington's fear that the Whiskey Rebellion was the fruit of these societies. There was too much difference between them in terms of their purpose, their function, their influence. But there was a shared membership, at least that I have to concede. Okay, so we can switch to the next one, which is going to be an image of the excise man. So the excise man in this case will be the federal tax inspector for all of Western Pennsylvania, named John Neville. This 1792 print represents his evil genius hooking him by the nose, center. To the left, you'll see him, this is almost like a pastiche, where, like a film, right? If you move it along, it's supposed to be in motion. He is hanging from a gallows to your left, and under him is the people have placed a barrel of whiskey, set it on fire with the intention of blowing him up, and the poem down below the description to your bottom center starts just where he hung the people meet to see him swing was music sweet, a barrel of whiskey at his feet, and then it goes on, of course. Okay, this gives you a sense of the kind of violence of which they were guilty. They hung them in effigy rather than actually hung them, but there was a lot of resentment against Neville in particular, because he had been against the excise in the beginning, but when he found the opportunity to link up with the federal government by becoming their tax inspector, he grabbed at it, and he and his network really profited from the years of the rebellion, and he was very much resented, and he will become the inciting figure of the violence of the rebellion in July of 1794. See the next one? And this shot is going to be of Washington leading troops. The date on it is 1793-1797. The Library of Congress can't seem to make up its mind. If it's 1793, it's related to the rebellion. If it's 1797, it's related to the debate over a standing army, which is not provided for in the Constitution. So what we do know is that the two figures behind the carriage wheel to your center right, and the figure lower right, underneath the wheels, are Republicans, Jefferson, Madison, and I forget who the third one is. I think it's Gallatin. And they're trying to prevent him from moving forward with an army, that is creating an army, commanding an army. And so if it is related to the Whiskey Rebellion, it would be related to Washington rendezvousing with troops in Carlisle that are going to go on and invade the West and quell the rebellion. Okay, next one. And this last one is here in Philadelphia. If you were to visit City Hall, stand out across the street and look at it straight up, you would look to the east end, and on that east end is a building attached, but built in 1790 to 1791 to house the U.S. Supreme Court. The U.S. Supreme Court met very irregularly until the early 1800s, so this building was used by the U.S. Circuit Court, and this is where the rebels would have been tried. One thing you should know about circuit courts is that they created more federal legal principles and more legal consistency than the Supreme Court ever did. They delivered 10,000 opinions, among them to the 38 opinions of the Supreme Court during the years from 1790 to 1801. They had the effect of enhancing judicial nationalism. Their jury charges, grand jury charges, were intended to educate the public and to bring them over to promote support for federal government locally. So they were very powerful and very influential. They had a mandate which was almost nondescript. That is, the Constitution itself did not give them a description of their role, and the 1789 Judicial Act did very little to promote that either. But they took it upon themselves as their responsibility to promote order among the states and to preserve the Union. So, rightly or wrongly, this is where this case will be tried. Just for your interest, one of the issues that I indicated, the 6 issues that I indicated that would make a difference to the trials, was the fact that the trials were going to be held in the U.S. Circuit Court. And why is that an issue? Let's see if I can find it. There were the law on where a trial should be held was fairly clear. Not fairly clear. I think it was clear to the point where there was really no discussion. The 1791 excise law, which was the first large-scale federal tax law, stated in it that the trials for the interference with the excise tax could be held in either the state or a federal venue. In 1794, it specifically allowed for prosecution in the same place where the crime occurred. So that's the closest controlling law you could have for where it should be held. So it should have been held in the county court, and the prosecution argued that case and said no, because the crimes were committed in multiple counties, and we would have to try them all in different counties, and it was a bad argument, but they won on another ground, which I'll discuss later. The 1789 Federal Judiciary Act designated state courts for capital cases. Treason was a capital crime. The 1793 Judiciary Act allowed for special federal circuit courts closer to where the crime occurred. That was applied for by the defense and denied by Supreme Court James Wilson, who was also the justice who authorized the federal invasion of the West in order to quell the rebellion. That under the 1792 Militia Act, a Supreme Court justice has to authorize the operationalization of federal force. So there was very little justification for this court housing those trials, except that the District Attorney General, Federal District Attorney General William Rawls, in a letter, a private letter to Alexander Addison, who was the president judge of the Western courts but a Federalist, wrote with a hint of sarcasm, "It would have been mere speculation to think the trials would occur elsewhere than in Philadelphia." So it was, again, somebody cut a deal. The Washington administration was not going to allow it to happen in a state county court, and so the Federal Circuit Court got it. And their justification was no more than it would be a great inconvenience to the prosecution. But the language of inconvenience in the controlling laws was largely for the inconvenience of the defense. Because if you are not tried where the crime occurred and you're tried 300 miles across the state, on the other side of the Appalachian Mountains, how do you get to your witnesses? And the right to trial by jury at this time was understood as a right to a jury of your peers, meaning your neighbors. It was in fact called, in quotes in many publications, a jury of your neighbors. People who know you, who know the situation of your locale, who understand the truth value of those witnesses. Actually, juries were supposed to know an awful lot. They brought in information, they were expected to bring in information from outside the courtroom into the courtroom in order to compensate for the fact that many of these cases were tried by judges on circuit who didn't know the local area. So, so the language of inconvenience was related to that. Okay, Cost, you can take that down and put the butterfly back. He's more pleasant to look at. All right. I would like to now start where I should have started, which is describe why there was a rebellion. The inciting act of the Whiskey Rebellion was an attack by a militia-led mob in mid-July 1794 on Bower Hill, which was the home of the Inspector of Revenue for Western Pennsylvania, John Neville. Well, here's how it started. At Cush's Fort, which was a place where Westerners would meet for local assemblies, but also it was related to militia musters. So you would rendezvous your musters, your militia, at the fort. So it had this double function. So there had been a meeting at Cush's Fort where a group had congregated because Neville had gone out with a marshal to deliver writs to distillers who were not paying the whiskey tax. And I think he had 50 writs he was delivering. And at the home of one, Oliver Miller, Miller wound up being killed by the soldiers. So they muster at Cush's Fort. This is the first assembly. So a party of rebels march on his house in retaliation. And then they come back. I don't know quite why, but nothing happened on that foray. And they meet and they instigate each other and they go back out again. And this time they're met by a contingent of soldiers that Neville has sent for from Fort Pitt. And the soldiers were not officially ordered to go there. But he had a familial relationship with Major James Kirkpatrick, and so Kirkpatrick puts together some soldiers and takes them there. So this is an unofficial act, mind you. And the rebel commander of the militia, of the rebel militia, James McFarland, comes out with a white flag to try to negotiate because there were some shots fired back and forth, and they take advantage of the opportunity, and one of Kirkpatrick's soldiers kills him. Kirkpatrick is taken prisoner, and the rebels return once more to Cush's Fort, but because the rebels who went to Bower Hill, to Neville's house, had no intention of engaging in armed conflict or to any act of treason. They had no intent. Intent was very important. So they kind of let Kirkpatrick escape. You know, it is the lesser of evils, so he gets out of it. But now we've had 3 meetings at Cush's Fort, all of them at a place where there normally had been assemblies, and this assembly was an assembly that was mixed with militia, and in each case was related to resistance to the tax. So we've got 3 assemblies there. They follow up with an assembly where they call on all the other counties at Mingo Creek, and that's it's a week later. Takes time to get there. And there, the rebels who are at Bower Hill say, we want you to make common cause with us, all 4 counties. Make common cause and support us for what happened, for the violence that happened at Bower Hill. And they delay. They say, we're going to call elected and or appointed representatives from each of the counties to a larger assembly at Parkinson's Ferry, and there we should deliberate on that matter. The moderates were trying to keep the rebels under control. The rebels go off and they decide that this is not good enough. So they provoke an incident by robbing the U.S. mail, bring the letters back, and read them at an assembly that they called Braddock's Fields. So now we're up to 5 assemblies. And at Braddock's Field, they instigate the crowd by reading letters from what's called the Neville Connection. This is the network of John Neville, the tax inspector's friends and relatives who are making money off of the whiskey tax. And it gets them so excited by this that they want to arrest these people, some of whom were living in Pittsburgh, and so they're going to march on Pittsburgh. Between the time they leave Braddock's Field and get to Pittsburgh, the moderates have gone out and bought up tons of whiskey, and are giving them out to them freely as they're marching. So by the time they get, it became a big party. And the people of Pittsburgh were forewarned, and instead of defending the city, they invited them in so they could party together. So that took care of diffusing that event. Rebellions are very much like this, if you've studied rebellions at all. We did a book, Costa and I, on the anti-Nazi resistance in the mountains of Greece during World War II, where all these groups of rebels against Nazi occupation, would defend their own villages, but they couldn't be assigned to another village because they didn't have any relatives living there. And when they saw their relatives working with the Greek government, which was working with the Nazis, they wouldn't go out and fight against them because after all, they're relatives. And people would go home for lunch, and that's the kind of thing you get here as well. Okay, so now we have diffused the march to Washington. Now we can go forward with this Parkinson-Furries assembly. Remember, where we were going to have elected representatives and everybody was going to come from all the counties, and that becomes the assembly that changes the trajectory of the rebellion, because now the tide is turned. The moderates make sure that all the moderates from the counties show up, even though they're terrified for their life, and they agree not to make common cause with the violence that the rebels have provoked. That would be now the action at Bower Hill, the robbing of the mail, and the march to Pittsburgh, which would have been enough in any other case to make for a wholesale revolution. And they turned the whole theme around to petitioning, to associating, to committees of correspondence, all the techniques that were used in the American Revolution to create a sense of commonality and a kind of responsible resistance. And they call it by the title constitutional resistance. We do not intend to overthrow the Constitution. We do not intend to overthrow the government. We wish to work within it and to respect its provisions, but we wish to honor the right to resist, using speech, petition, association, the right to bear arms, and the right of assembly above all else. And this is where they stood, and that became one of their biggest bargaining chip in the trials themselves. So Washington then has to take some cognizance of this, and he calls the cabinet, his cabinet together, and he asks for their advice. And of course, Alexander Hamilton, who's on top of everything. I mean, this man is a marvel. I don't know where he got the time, but he had already anticipated that Washington would call this conference, and had written a letter to him. As soon as he calls the conference, he writes him a letter immediately. It was after, as it was over, before any of the other cabinet can get to him. But thankfully, the Secretary of State, Edmund Randolph, kind of diffused his influence, Hamilton's influence, and the idea of authorizing a militia to march west. He couldn't get them to undermine that entirely, but he got them to agree to sending a U.S. Peace Commission west while they were getting the militia ready. So, they say, be good if you can, evil if you must. That's Machiavelli. Washington is working both sides of the coin here. So they have the presidential conference, the conference with the rebels, but they do nothing except their instructions are not to discuss their grievances, to offer them amnesty for submission, which sounds very much to the rebels like what King George said to the colony when the colonies presented them with their list of grievances. He said, submit or triumph. In other words, give in or fight. This new King George, Washington, says basically amnesty for submission, which is his equivalent trade-off. So he really inflamed them. And then they went on to the Brownsville Assembly, which is our 6th assembly now. And at Brownsville, there were lots of petitions and lots of resistance to the idea of conceding through submission. But immediately following the Brownsville Assembly, the invasion happens in October, and the rebellion is over. But it's over also partly because the moderates had organized the assemblies, they had made speeches, they had had debates, they had quelled the mob, they had created an institution in those assemblies. And I think this is one case where I will have to reluctantly concede that Washington's instincts were extremely good. He understood something that nobody else really grasped. It is my view, looking at all the documents, that if you just sit down and make a comparison between how the American Revolution organized itself to overthrow the British Empire, it is very much, and by intention, like what the Whiskey Rebellion did in its assemblies. It's the same process of forming a rebellious structure. They simply replicated it. They created a kind of legitimate, representative, alternative form of governance through their assemblies. The justification for doing that for the American Revolution was that the American colonies were endowed with legitimate rights of Englishmen. And those rights that they relied on allowed them to create committees of correspondence and assemblies and petitions, which gravitated to the development, to the foundation of the Continental Congress, which was well before the Revolution actually started. I think it was 1774, and then the Continental Congress delivered petitions like the Declaration of Rights, which became the Declaration of Independence. I think Washington's instincts, because he was there, he knew what was happening. He was part of all of that. His instincts were right, that the rebels presenting their grievances to the U.S. Peace Commission is the equivalent of that petition of the Declaration of Rights that was delivered under the Continental Congress. And those assemblies were very much like the Continental Congress in terms of their having organized themselves politically, organizationally. They voted, they debated, they delivered resolutions, they communicated with Congress. Under those grounds, and also recognizing that the Continental Congress commissioned George Washington as the commander of the First U.S. Army, and understanding the role that the militia had been playing in these various altercations and the confusion between assemblies and militia rendezvous, I think he concluded that to take this seriously. Whereas the rebels simply relied upon the Bill of Rights and the rights they were granted therein under that and the Second Amendment militia right, they thought they were conducting themselves according to constitutional resistance. And I think that that's the real conflict, the parameters of the rebellion. Okay, so we are now at questions of evidence. And I have everything numbered here. Here we go. I said that we would be looking at how the rebels represented themselves and why the trials did not result in any executions and only resulted in 2 convictions. And that includes all the misdemeanors that were charged as well. I didn't go through those because they were not for treason. They were for misprision of treason or for misdemeanors of speech, symbolic speech like the raising of liberty poles or seditious speech. But still, there were no convictions there either. And how did that happen? Well, one reason was that the evidence that was brought to the trial was brought there by William Rawls, the prosecutor, who had gone west with this federal militia and had interrogated and investigated the crimes, interrogated all the witnesses and the rebels. But he allowed prejudicial testimony, he disallowed hearings for the rebels. So there were lots of questions of evidence, corrupt evidence that left out open all kinds of procedural challenges for the rebels when they finally got to Philadelphia. Hamilton was a big player here. Washington went home after Carlisle. He did not, contrary to what a lot of historians represent, lead his forces into battle. Carlisle was quite a distance from the western counties. He went home. He did the grand cavalcades. He, absorbed all of the adulation of his troops, and then he played the Roman general Cincinnatus and retired into the sunset. Hamilton, with no official authorization, no title, just got on board and went along with William Rawle, the prosecutor, and decided that he was Washington's representative in the western counties, and he would assume the role of the head of the judicial arm of the federal militia. So he was in charge of these interrogations. Well, there's no surprise that he was in charge of the interrogations, because he already had a set of spies all set up in the western counties since 1791. He's been agitating for this, for 3 years, because he wanted to make this a test case so that he could demonstrate the importance of the taxing power going to the federal government having the taxing power. He had tunnel vision on these financial issues, and he wanted to pay off the speculators who had invested in the war. But after the war, speculators had bought up all the vouchers that the Revolutionary Army had put out at pennies on the dollar. Sounds familiar? Pennies on the dollar. And Hamilton's role was to get Congress to reimburse them at 100% value. And in line with that, he got this federal excise bill, which was a whiskey tax, passed. So that, if you tax people in the West and you live in the East, no harm, no foul, right? You're clean, you're clear. But it didn't work out that way. So he had to make sure that this worked out for him because of his financial machinations. Well, he had a group of spies who sent him back letters about what the rebels were doing, but they never went out into the countryside where the rebels were because they were afraid. And their letters, volumes of letters, demonstrate exactly that. So the information they were sending back was contaminated. It was largely fabricated. And beyond that, when he himself represented in his own letters that he neglected to gather formal evidence when he was in the West. Why? Because there were unsafe conditions in the Western country, and he was unable to foresee what kind of information the trials would need. He says, moreover, in quotes, these materials are susceptible of different interpretations, and testimony would, after all, be liable to specious controversy about their true import and nature. He goes on. He says, the material I would have collected had I collected it would frequently discover itself in forms so plausibly disguised and with so much duplicity of aspect as not to be capable of being rendered palpable by precise specification and proof. So because he couldn't prove it and specify it to anybody's degree of satisfaction, why bother collecting it? So that's the question of evidence. Well, when the evidence came to trials, surprise, surprise, many of these trials just were dismissed because there was no evidence on which to base the charges. The question of vicinage, where you're going to hold the trials, we've already covered. It went to the circuit court when it really, by controlling law, should have stayed in the places where the crime occurred. But that was also the result of the way the treason trials in the American Revolution were held. The Pennsylvania Supreme Court routinely usurped the authorities of the county courts to bring cases before them. And they would even go out on circuit to do it if they had to, but they largely haven't brought all the way to Philadelphia. So they had that precedent, and they just capitalized on it. Procedural issues were largely the result of the corrupted evidence that was collected, or was not collected, and the others related to habeas corpus petitions, to witness lists, copies of indictments, which were not provided by the prosecution, all of which, interestingly enough, go back to protections under English common law that date from 1696 and 1714. Those are really kind of simple mistakes to make. It was the level of arrogance of the prosecution that did them in, because they didn't touch their bases. You know, there was no reason they should have lost on these issues. I would like to say that the judge in this case, who has been really read over the coals for the way he handled the trials, was possibly the most responsible person of all on either side in the treason trials of the Whiskey Rebellion. He insisted that the law be followed to the letter. And he got them their copies of indictments, he got them their jury lists, he got them all the things they were entitled to. On the other hand, he was a Federalist, and he wanted to make sure the trials were done properly, so if convicted, you know, the government would be good law to follow for future rebellions. Okay. The question of jury selection is the next one, and then there will simply be the questions of constitutional interpretation to get us through the trials. Jury selection, defense made a lot of fuss about getting the law respected from the Judiciary Act of 1789, which provided that 12 jurors be summoned from the locale where the events occurred on each panel. Well, all that added up to was 16% of each panel would be people from the West, to give them what they would consider a fair trial. And they were held in a handbasket to get a hold of, because they weren't going to get paid, right? And they had to come over the Appalachian Mountains, which was, you know, we didn't have the portage system that we had later. And as it turned out, everybody studied, you know, what jurors rendered what verdicts. And was it where you had more Western jurors on the, you know, where the challenge, you get something like 35 peremptory challenges, 35, yeah. When you had more Western jurors proportionally, did you get the verdicts that you wanted? It turns out it was absolutely unconsequential, because there were so many people in the city of Philadelphia who thought the rebels were being treated improperly. And they were looking so much at the question of let's see if I get this right, the veneer, the panels you put together, as opposed to voir dire, the way you interrogate individual jurors. They were paying so much attention to the panel and not to the individual jurors that defense got better people on the panel who were actually anti-government, anti-federalists. So again, it's a question of paying attention to the details, you know? So the prosecution lost out on that as well. But one thing I thought you would be interested in would be Rawls' comments. William Rawls, the prosecutor, was always looking for somebody to scapegoat. He was an honorable man. He just did not do his job very effectively. And his comments about the preparations for the trial with regard to the jury. At the last sitting of the circuit court, it was discovered that a great unwillingness to say too much against their fellow citizens on the part of the jurors, a reluctance in the jury to convict the smaller engine on the testimony of their ringleaders, in other words, people who actually played a big role in the rebellion, wound up using what's called the reward system. They would, what's the word, turn over their testimony against others so that they would not be tried themselves. And based on that, their testimony was close to perjury, and the jury figured that out. So that strategy did not work well for Raw either. In some instances, bills were returned ignoramus, they couldn't get indictments, contrary to what appears a grounded expectation, contrary to what he thought would happen. And it has to be attributed, he wanted to attribute it to the different ways of doing law in different jurisdictions. In other words, maybe I should have had it tried in the Western jurisdiction, I wouldn't have ran into so many troubles. But the way they chose the jurors was really interesting, and it was interesting for you because a lot of it involved Quakers. Should we call the Quakers or should we not call the Quakers to serve on these juries? So, defense counsel Thomas left the case to 12 Quakers, but many of them were Tories. Tories were loyalists, British loyalists during the war. But his presumption was that Quakers would not condemn the prisoner. And the quote in the letter is, "In this Gallatin allowed," the letter writer, "Thomas was much mistaken." So that accounted for having Quakers on the Mitchell jury. Only 2 people were convicted of all the rebels that were brought to trial. And Mitchell was the one who had the Quaker jury. So I think that's kind of interesting. On the other hand, Hugh Brackenridge, who wrote the dissertation on treason that would have been the defense's treason strategy, this is a quote. He always chose a jury of Quakers, or at least Episcopalians, whenever it was murder or rape. But in every possible case of insurrection, rebellion, and treason, give me Presbyterians. In any case, predicting the verdicts by virtue of the makeup of the jury, whether they were Easterners or Westerners, whether they were Quakers, Episcopalians, or Presbyterians, didn't count for much.
Well, Linda, thank you very much for an extraordinarily enlightening hour. We usually allow for a few questions. Are you up for that?
Yeah.
So, questions?
People who need to eat, go eat.
I just wondered, was there any appeal from this court proceeding, or was that the final supreme?
From the Whiskey Rebellion trials?
Yes.
They were all pardoned. The juries in both convictions unanimously wrote to the President of the United States and begged for pardon, for clemency for those 2 who were convicted. They were not ringleaders. They were just, I'll just use in quotes, poor Slavs who got caught, hanging around the wrong people. That was basically how they described it in the literature.
So then there was nothing to appeal.
Nothing to appeal. Everybody got caught. What did they say in Never on Sunday? And they all went to the beach?
To the shore.
To the shore.
Did Hamilton get his desire that he establish the supremacy of the federal government to tax after that?
Oh, he did more than that. He got a national bank established. He privatized the banks. They had been public banks, and they had given public loans to all the farmers in the West. Well, their punishment was that he privatized the banks, and only the speculators, land speculators, got loans after that. So yeah, and you have to give Hamilton credit. He stabilized the American economy, and his financial plans were, very respected, but he was a bastard. Yeah. Okay, guys,
It's like,
thank you.
that's it. Thanks again, Linda.